I am ready for argument, and I will start with plaintiff.
Thank you, Your Honor. Again, my name is Ken Anderson, and I would put it, I have the honor of representing Barry Brigham, who is quite a character, as the court might infer from the pleadings here, which are voluminous, and I appreciate that the court's description of them. This case is not about Barry Brigham not paying his rent. This is not about him being delinquent in his rent. And despite what the defendant seemed to be putting forward, he didn't abandon his property. It's undisputed that Barry stayed current in his rent, and also that the defendants terminated his tenancy. And my impression, and I think the testimony is pretty clear, they didn't like him. And they issued an eviction, which was in essence a default, but they gave him no opportunity to cure that default, as their contract states. This is both a contractual dispute and statutory. The defendant seemed to be saying that the statute doesn't apply because he wasn't behind in his rent, and that therefore the protections that, or the obligations that the statute for the storage unit, RCW 19150, imposes upon them.
This case isn't about unpaid rent. That's what makes it so unusual. Both sides agree the tenant kept paying, but they completely disagree on what happened after the storage unit was terminated. The plaintiff claims he was unfairly locked out and his property was sold without proper notice, while the defense insists they were simply enforcing the contract. Now the court has to decide which version of events is supported by the evidence.
They somehow get around it because he was current in his rent, therefore they don't need to provide all the protections. Well, at any rate, Barry, who's an older fellow, he hired workers to help him try to get out. He hired a semi to help get his stuff out. And the defendants called the cops on him and tried to get it done early. And now they're saying that he abandoned the property. So he's threatened with criminal trespass if he goes to get his property. And now they're saying it's abandoned. They didn't offer him any opportunity to cure the defects. They said he was using it as a residence. They said because he brushes his teeth there. I think they nowhere say that he is spending the night. And we are asking the court to find that, just as following the contract, that they have violated the contract, the defendants have, and that they are liable for Mr. Brigham's damages after that. The statute requires that the defendants, in their offer to sell the property, notify Mr. Brigham. They did not. There is, I think, an interesting factual issue, if you will, about to whom they sold Mr. Brigham's property, whether it was an employee. I think it's clear that, as he is known, door guy Bob had received money from the defendants. It appears that he would repair the doors at the storage unit. This was not an arm's length transaction. It just appears that they pushed him out, locked the doors, sold the property to Bob, and then bought it back, and they've yet to give the money to Mr. Brigham. The central facts here are just not in dispute. Barry Brigham is eccentric. He had a lot of property in the storage unit, and the defendants have confiscated it in violation of the statute and significantly in violation of their contract with him. Your Honor, I'm just looking through my notes here. Barry even offered them additional rent, trying to buy more time. And the defendants admit that he was just, he was forced out of their place of business and have incurred their own liability because of it. And that's what we're asking the court to do today, is to find that as a matter of law, that the facts are not in dispute, they violated the contract. And I'm also asking the court, we are asking the court to find that they violated the statute. Thank you, Your Honor.
Thank you. Okay, for defendants, Mr. Campbell, go ahead.
Yes, good afternoon, Your Honor. There are a few things that I want to correct, and I'm sure you've seen the briefing where I correct the record. Defendants have not provided any testimony in this matter. 2 fact witness depositions have taken place. Those fact witnesses do not testify on the behalf of my client. They were not noted under CR 30. They are not providing any testimony. This kind of weird theory that plaintiff's counsel continues to rely on, that Robert Ansel is an employee, is again factually incorrect. And not only that, he's produced no evidence to support that. And again, I do think it's important to point Your Honor to the repeated incorrect case citations and incorrect statutory references in plaintiff's briefing. Again, I don't know if that's AI generated or if it was a unintentional misstatement of the law, but there are numerous incorrect statements that have been made on the record to this court, some of which, again, I pointed out that no, Mr. Ansel is not an employee. That has never been corrected. But to get to the merits of the argument here, one thing that counsel did not mention in his opening, which I think is very important to note, is that this contract, this self-storage agreement, includes a voluntary termination. You have it in the exhibits and in our briefing, but either party may serve upon the other at least 10 days written notice of intent to terminate the tenancy, containing a specific termination date, which said date shall be the last day of a rental period, and the tenancy shall thereafter terminate on said date. That is the basis for my client's right under the contract to terminate a tenancy. There's nothing that prevents them from doing so, from voluntarily terminating the tenancy, that would require some kind of cure period. Again, counsel seems to want to make this a default fight because that would benefit him. Again, it wasn't. It was a termination of the tenancy. There was no default, and that distinction is crucially important when reading the Washington Self-Storage Agreement Act under RCW 19150 and applying those in his attempt to apply those statutes to this case. Again, I think that the plain language of those statutory schemes are clear. That whole principle of the self-storage agreement is what rights do landlords have to get a lien on property when there has been a default in rent payments. There's no discussion in there about what happens when a contractual provision in a storage agreement is violated unrelated to rent. Again, I pointed out, I think every single portion, every single subsection of that statute relates in one way or another to payment of rent or a lien on property and the steps that you have to go through to enforce that lien. Again, we are very clear here. Plaintiff never failed to pay rent. That was not the issue. My clients chose to terminate this tenancy under the voluntary termination provision of the contract because Mr. Brigham was engaged in inappropriate, prohibited uses on the property. He was, in fact, staying on this premises throughout the day as a pseudo home during the COVID-19 pandemic. He wanted to social distance and he had roommates at home, so he would go to the facility on nearly a daily basis, stay there for long periods during the day. He would take naps in his truck. He would heat up food in a microwave, which is prohibited under the electrical use prohibition in the prohibited uses section of the contract. He would urinate in a bucket and go dump the bucket out and near the premises. And this was a pattern that was ongoing. My client's former employees felt uncomfortable around Mr. Brigham. They felt threatened by Mr. Brigham at times. And again, under the contractual provision that allows for voluntary termination of a tenancy, my client exercised that right. Mr. Brigham doesn't get to somehow cure when my client has a voluntary ability to terminate this tenancy. Again, if this was a default of rent circumstance, we'd be under a different grounds here. We would be within the scope of the default provisions and those requirements set forth in RCW 19150. We're not. We are in a contract that was agreed to by Mr. Brigham and that he chose to blatantly disregard on numerous occasions that my clients have, determined, no, we're not going to move forward with this anymore. We're going to terminate that tenancy. They gave him more notice than required by the voluntary termination provision. They gave him a full month to get his stuff out. He delayed. He didn't take necessary actions to clear it out. He cleared some of his storage out, but he eventually had run up his time. My clients gave him an extra day to keep going, and at the end of that, he still wasn't able to get his stuff out. The contract also provides for an abandon or surrender of property, and that we can dispose of it how we like, how we choose when you've left property on the premises. The
So
eviction.
tell me, I'm looking at that. The surrender, I think you're relying, so let's kind of putting aside whether the termination was proper. I'm just looking at, okay, let's even assuming it was or wasn't, but let's talk about surrender and abandonment. So I'm looking through that. Is it, so notwithstanding, are you relying on the language, notwithstanding the foregoing provisions, landlord may at landlord's sole discretion discard, dispose of, donate, or sell any personal property abandoned by occupant, publicly or private, or if required, then dispose of the same pursuant to any applicable law. Any stored item not removed promptly upon the termination of tenancy shall be deemed abandoned.
Yes, Your Honor, that is exactly the provision that we're relying on. Again,
Okay.
there are different requirements under the statute when there is a rent default circumstance. This is not what we're faced with. We are under the contract provision here.
Now the defense is revealing its entire strategy. They're arguing this was never about missed rent, it was about repeated violations of the storage agreement. According to them, the tenant had plenty of time to remove his belongings, failed to do so, and under the contract, anything left behind was considered abandoned. If the judge agrees with that interpretation, it could completely change the outcome of this case.
Again, we provided plaintiff with the notice more than a month before his termination date. The notice explained again that you need to pick up your property or it will be deemed abandoned pursuant to the contract. And pursuant to the contract, his property was abandoned when he failed to remove it with a full month to do so. I think it's somewhat ironic. I pointed out in the storage agreement that plaintiffs or tenants, excuse me, are limited to keeping $5,000 worth of property on the premises unless they get specific permission. Well, if he only had $5,000 worth of property on the premises, he probably could have moved it out a lot easier than having to fill up buses or truckloads of property. Again, he's making claims that his property is worth over $200,000. He's produced no evidence to suggest that he had that approval. In fact, his deposition made it very clear that, oh, yeah, it was in there. I was aware it's in there, but I didn't care. And I think that the theme of his tenancy is, yeah, I'm aware of the rules. Yeah, I'm aware of the contract, but I don't care because I'm Barry Brigham. When you look at the contract, He repeatedly breached the contract, and my clients exercised their option under the voluntary termination provision to terminate that tenancy. Plaintiff failed to remove the property from the premises within the 30-day window, not the 10-day window that we could have provided, but the 30-day window and the extension that we gave him. He still failed to remove his property, at which point it became abandoned, at which point we can essentially do with it however we please. Again, we can sell it publicly or privately. There's no requirement that we let him buy this back. There isn't. This is a contractual issue here. And we followed the contract in the disposition of the abandoned property that was left there. Your Honor, they have heavily relied on the provisions of RCW 19150. I briefed it out pretty heavily as far as the plain language and the legislative history. I won't go through all of that again here unless you think that it would be valuable for your understanding to go through the legislative history and each individual statute to show that, yeah.
I'm good. Thanks.
Excellent. And unless you have any other questions for me at this time, I'll rest.
Okay, thank you. Mr. Anderson, any rebuttal?
Yes, Your Honor. Counsel refers to the $5,000 limit, which they sought in summary judgment previously. And I think it's rather disingenuous to bring it up again, that this court found that it did not apply. And I think that it shows the intent of the defendants here to take every advantage that they can of the facts and the law. Mr. Brigham, this was during COVID. He did not unreasonably delay in trying to get his property. He hired people to help him. He sought semis, and the defendants chose to ignore that and declare his property abandoned. And we are asking the court to find that as a matter of law that the contract was violated and that the statute was violated. We're not asking for damages at this time, Your Honor, just liability. Thank you.
Understood.
And
So I'll let the
Your Honor,
parties.
can I briefly respond?
Are you going to talk about the 2024 summary judgment order?
Yes, Your Honor.
Yeah, I have it up in front of me. Go ahead.
Okay. I think it's very important that the court did not, as a matter of law, say that that provision is not enforceable here. Basically, Judge Basser said, well, it depends on the circumstance. If you had materially breached the contract, if that's what is found at, the time of trial, then it would, but you may not be able to rely on it if you too did some bad act, if plaintiff wins on that. So for counsel to suggest that this is, as a matter of law, it's not applicable, that just misstates this court's ruling.
And I had reviewed that and I pulled it up again, and conclusion of law really number 3 is, to the extent the terms of the storage agreement are determined to be valid, enforceable, and applicable, there is a $5,000 property value limitation contained herein. However, that may not limit recovery depending on the facts determined at trial. I know at least one of the parties or attorneys was different in 2024 as now, but at that time, Judge Basher said, hey, I have some real questions about disputed issues of material fact. As I review this case and the large amount of documentation, I am still left with that question. And I think that's the ultimate question that this case hinges on is, I don't even think you get to liability for the sale of the belongings until someone first says whether the manner of termination, eviction, ending the contract, breaching the contract, whatever it ends up being, until that issue is decided. So, I continue to stand, I think, with the spirit of the ruling in 2024, which is I think there are very significant material issues of disputed fact that need to go to a trier of fact as to the manner, method, and grounds for ending this relationship. Whether or not the defendants did it correctly will ultimately determine whether abandonment and sale of property was done correctly. So I am going to deny plaintiff's motion for summary judgment. I do believe there are, again, material issues of fact. Some of it may be balancing of credibilities of testifying witnesses, which this court won't do on summary judgment. So I am going to hopefully move you all forwards towards requesting a trial date. I know this case has been going on for quite some time and you all need resolution. So I'm going to deny the motion for summary judgment. If someone can get me an order to sign, that would be great. Otherwise, I can put you on for presentation in 2 weeks.
Your Honor, we submitted a proposed order on plaintiff's motion for summary judgment. It's pretty simple. It just says it's hereby ordered that plaintiff's motion for partial summary judgment is denied, and that there's some lines in there. It is further ordered that if there's anything the court needs to clarify, but I believe that is with you at this point.
Do you know when? Hold on.
It would have been submitted with our response on the 21st of May.
Oh, it probably got scanned in as proposed. Let me just see if I have it in proposed.
Yeah, I think it is listed as bracketed proposed in the caption and the footer.
Well, I don't have it. Is that something that your office could email to my judicial assistant and copy opposing counsel on? And if you want to take out the word proposed, that'll make it even quicker for us.
Okay, yeah, happy to do that. I will just make those 2 changes, pulling out proposed and circulate to you with counsel copy.
Okay. Perfect. Thank you.
Thank you, Your
Okay,
Honor.
thank you both. And then for whoever wants to get this noted on to set a trial date, you could note it on for any universal trial assignment docket to get a trial date. We do universal trial assignment dockets every Wednesday at 9 a.m. Zoom only.
Thank you, Your Honor. Thanks,
Yeah.
counsel.
In the end, the judge didn't decide who was right, at least not yet. Instead, the court ruled that there are too many disputed facts to resolve the case through summary judgment. That means this lawsuit is headed toward trial, where witnesses will testify and the evidence will be fully examined before a final decision is made. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.